All right, I will now turn this webinar over to Brooke Dorr, the center's senior staff attorney. Brooke joined the Center for Agricultural and Shale Law in 2019. Prior to coming to the center, Brooke served as chief counsel to the Pennsylvania Department of Agriculture, and before joining PDA, he practiced law in Lancaster County for 18 years. Brooke, the screen is yours for understanding the basics of Pennsylvania's Clean and Green Preferential Tax Assessment Program.
All right, thanks, Audrey. I think everybody can see my screen. I'm going to just do one little advancement to see if it, yep, okay, good. You saw that just change, right? Okay, just making sure. All right, so beautiful day today. Sun is out here in Lancaster where I'm sitting anyway. And what better day to talk about my favorite subject, clean and green, which I'm laughing about it, but I'm also somewhat of a sadistic person who loves clean and green for some reason. I don't know why, but hopefully you love it as much as I do. So we're going to go through this as quickly as we can, because I am so notorious for taking too long and talking too much. And so we will see how that goes. The one thing that I have like 38 slides total, but some of those we already went through. So, you know, sometimes you try to figure out, maybe I got 30 slides. So I got 2 minutes per slide. If I take a whole hour, well, I got to do quicker than that. Well, that's tough when you start thinking of it in those terms, but let me just make my way through my slides. So we're going to talk about clean and green, and this will be a sort of an entry level. So for those of you who know it well, you may not hear anything particularly new. There hasn't been a whole lot of new things going on in clean and green in recent even years, really, which is unusual because this is a statute that does get frequently visited by the legislature, just has not been in the last few years. And I do believe we're accurate in saying 2016 was the last revision, and then there were a whole bunch in the period between like 2010, 2012. Of course, much of that had to do with Marcellus gas exploration and how to work that into and make it sort of compatible with the clean and green restrictions. So, and we'll talk a little bit about that, but probably less than some people might want, because that's not quite my favorite part of clean and green. I was Department of Ag when that was all going on, and I was intimately involved in crafting all that language, and I guess maybe I'm a little burned out on it. But in any event, okay, so Clean and Green is the program where qualifying farm and forest owners, landowners can receive a preferential property tax assessment based on the lands, and that's the key principle, based on the land's current use rather than its highest and best use, which is sort of the principle behind property taxation, at least in Pennsylvania. And then, of course, we have these constitutional requirements with regard to uniformity too, but this is a program that creates, a form of non-uniformity, which is interesting in and of itself. So we'll talk about why that is in a second. So a lot of states have these. They have them in different ways. The basic concept is always there, that two ways you could look at it. One way is that farmers need reduced property taxes in order to keep their farm viable, rather than being taxed on a value that's based on the development potential of property. And then, others would say that part of the justification is also that we want to encourage open space, and we want to create a better ability for those who own property that is undeveloped to keep it undeveloped. That kind of goes hand in hand with what I said about farmers needing perhaps a better property tax system to remain viable and not be compared against land that is in the mix to be developed for a shopping center or residential or whatever. So kind of the two justifications, and it clean and green, which means clean means you're looking at something that does not have development on it, and green, which means that it is pleasant to look at, and that it is natural, and it's giving you a viewscape. We all hear about viewscapes these days with regard to solar development. Or at least that's one of the areas we hear about viewscapes. So these were important things to the citizens and the legislature of Pennsylvania, going back, into the late 60s and through the early 70s when this law was enacted and became effective in 1974. And has been with us ever since and has been extremely successful in terms of at least the numbers of people and the numbers of acres that are enrolled and the numbers of people utilizing it. We'll actually go over those numbers. So we're going to provide an overview of the Clean and Green program. We'll talk about the eligibility and enrollment criteria. We'll review the restrictions that it places on land uses and the changing of land uses from the enrolled use that the land is in. We'll talk about what's allowed and what isn't, and we'll talk about rollback taxes, which is the concept of if you change the use and you not adhered to the requirements of being in the program in exchange for the tax breaks you're getting, well, then you're going to end up having to essentially, you're going to have what's the proper word in this context? We say rollback, but you're going to have to end up, paying some of that tax savings that you realize back to the government if you don't comply with the program's terms. So let's go ahead. I'm already way over my 2 minutes per slide. All right, here are some links to things that Audrey had mentioned that also in my PowerPoint. Here's the statute. And that's the formal name of it, not Clean and Green. You won't see the words Clean and Green anywhere in the law. You'll see them in the title to the regs, however, and bullet point 2 shows you where the regs are, and that's a link to the regs. And by the way, with regard to the statute, this is the Purdon's version in the long, 72 PS, et cetera. And then in the parentheses, I have the easier to read copy, which is more of a Word document that is much nicer to look at the statute from beginning to end. And that copy was in fact produced by our friend Dwight Smith, who was the 20+ year counsel to the Bureau of Farmland Preservation at the Department of Agriculture, now retired. But all you have to do is click on there and you'll see the evidence of Dwight's handiwork all through that document. He created it from scratch and he was the master of those kinds of documents. Now, Clean and Green program is a voluntary program that counties can elect to participate in. It is not a mandatory program from the state. Counties can say no. 60 of 67 counties have said yes. The counties that have said no are Clarion, Crawford, Forest, Franklin, Jefferson, Mercer, Northumberland. They have no Clean and Green program. Every other county has some form of Clean and Green program, even Philadelphia County. Why do these counties not have a program? Well, the conventional wisdom would be that their real estate values were low enough to begin with, or their assessments at least were low enough to begin with, that they did not see a benefit to this. But there are other reasons which we will talk about. So will that list of counties change someday? Perhaps, although I'm kind of thinking that we might not see that because of some of the controversy that swirls around the program. It might be hard to essentially go in that direction now in some areas. I do find it pretty surprising that Franklin County does not have a program. I'm not such a student of some of the western counties like Clarion and Crawford and Forest to know. I'm from Indiana County and I know a bit about Jefferson County and Mercer out there also. So they have some unique, circumstances in those counties. Northumberland County, sort of an island into itself as a county that doesn't have a program. But Northumberland County probably has a lot of things that are unique to it. Now there are some limited, even though it's elected or a voluntary program that can be elected to be engaged in by counties, there are some limited but mandatory administrative duties that are given under the statute to the Pennsylvania Department of Agriculture. And as Audrey said, there's their website, the Bureau of Farmland Preservation, under Doug Wolfgang for 20 years or so, was the administrator of all of those duties. And now it is Stephanie Zimmerman, who had worked under Doug for years, and Doug is now the executive secretary of the State Conservation Commission. So congratulations to Doug. Now, this is the authority in the Pennsylvania Constitution, which allows us to have a non-uniform property taxation system with regard to this particular tiny subset of property. And essentially, the version or the excerpt of the Constitution says that, and it was enacted, and I should have put a date in here, as somewhere in there in the early 70s, that it was approved for the legislature to establish standards and qualifications for, and this is where the category, the use classifications or the use categories was invented, the terminology, private forest reserves, agricultural reserves, and land activity devoted to agricultural use. So that's where those words actually came from, is the constitutional amendment, and make special provision for the taxation thereof. So this is what authorizes non-uniform property taxation in this particular instance. Now, the overview of the statute, again, allows property to be valued as it is being used, or in accordance with what's called a use value, rather than the standard fair market value, which has that concept of the highest and best use embedded within it. Now, if enrolled land is assessed, enrolled land is assessed on the income approach to land appraisal, which is essentially a way of measuring, the amount of income that the land can produce as agricultural use, or in agricultural use, and then in forest use. So it gives both farmers and those who maintain, forested lands a tax break, again, to try to incentivize them to keep that land undeveloped. And according to the PDA Bureau of Farmland Preservation 2021 annual report, 10.8 million total acres of the Commonwealth have been enrolled since 1974. I think that's currently enrolled, I should say, because some has departed the program for various reasons, which we'll talk about. There are 214,000 separate parcels enrolled, and that the average reduction in fair market value for the tax assessment for enrollees is roughly 50%. So averaging out the reductions across the whole state, that's a very impressive number for a program to achieve for the citizens. So it's a job. It is a mission accomplished in terms of legislative intent, anyway. Now, the three categories, as we said, agricultural use, ag reserve, and forest reserve, are the three categories in which you can enroll your land, and they all have their own unique requirements. One requirement across the board is that all enrolled land has to at least consist of a minimum of 10 acres. However, asterisk here, which is in ag use. If you're enrolling there, you can have a smaller tract than that if it's capable of producing greater than 2,000 or greater than or equal to $2,000 in annual farming income, which isn't a heck of a lot. And now this gives you a little breakdown of real general concept of the definitions. Ag use is used to produce ag commodities commercially. Right now, there's approximately 4.5 million acres enrolled in that category. Ag reserve, non-commercial open space land used for recreation and scenic enjoyment that is open to the public free of charge. About 600,000 acres enrolled in that category. And forest reserve is 10 acres or more of forested land capable of yielding timber or other wood products. And that totals about 5.5 million acres. So a little bit more than is in the ag use. And then obviously the ag reserve category is much, much less than any of those. The ag reserve category has its own little history story, and I'm probably going to stay away from that to some degree here because it's important really to understand these other ones. I think it's important to understand this as a young lawyer. If anybody here is just starting out, I did not understand this at all when I was a young lawyer, and it took me a while to get it. And it's so important and impacts so much. Almost any land development idea has to start with, is this land enrolled in Clean and Green or not? Because that's going to dictate a lot, and people inadvertently make mistakes and have bad consequences by not answering that question first. And I honestly mean any land development, because you can make a very bad mistake very easily in doing improvements or pursuing some type of change in the use of land that is enrolled. This gives you a map here, next slide, of it is available on the PDA website as part of the Farmland Preservation Annual Report of 2020 is the last one that's accurate. And this map gives you, or the last one that contained this, I should say, and this gives you a idea of the counties that are most heavily utilizing their program. And the darker the blue tint here, the more acres in that county are enrolled. And you can see the key down here and get the flavor of things. You know, you've got some obviously solid ag areas, you know, Berks, Lancaster, York, Chester, Adams, and then here's Franklin sitting here with no program, but also, you know, really coming on as a you know, hotbed of ag and ag development for that matter. You know, Bedford, Somerset, some logical candidates, Center, you know, Clearfield, Washington County out here by Pittsburgh and Allegheny County. And then this gives you these the darkest gray tells you that where there are no programs, and I think that's the 8 that we identified, including now Philadelphia. That's not right because I think they do have a program. So I believe that they just did not report in this process. Non-participant, they're under that non-participant, or I should say unreported is where they are. Not a non-participant, they're just unreported. So, okay, that gives you a breakdown. It's a neat thing to look at and analyze. Now, the overview. A county's voluntary election to have a clean and green program means that the county has chosen to forego imposing and transferring some portion of their gross real estate tax burden that's necessary for that county's needs. They've chosen to essentially transfer that tax burden, so to speak, from clean and green enrolled land to all other lands in the county, because they probably have a gross number they need to operate their county government, and they need to generate that much tax revenue. And so it is a program whereby property enrolled gets a tax break, and theoretically, by essentially the process of government meeting its needs, theoretically, all the other land is having some type of incremental increase to make up the difference. So it's really a big policy choice by a county to have a program. The more property that's enrolled results in either a reduction of their gross tax revenue or an increase in property taxes. One or the other has got to happen. And that's, of course, meaning primarily school taxes. So this is not a program that is without its detractors for this exact reason. And you might say that school districts are probably the main entity that suffers an impact from robust enrollment in clean and green in a particular county. Let's just put it that way. Okay, now, big feature of the program in a general overview is the concept of changing use and a rollback tax assessment. So I'm putting that right up front to tell you what this is all about. And that's what everybody wants to talk about. Okay, now, land use that has changed from an eligible use under which it has been enrolled to some type of ineligible use, which could be it's gotten less than 10 acres, or there's been a subdivision or a conveyance, or there's been an actual new activity going on the site, like we built a retail store for our farm or whatever it may be. If you change from an eligible use to an ineligible use in some way, then you're subjecting that enrolled land to a rollback tax that is assessed as the last 7 years of tax savings. So if you reduced your tax by 50%, as that one figure said to us here earlier on an earlier slide, then you're talking about, if you got a tax bill of, $30,000 on, a big spread, and you've been paying 15 for the last 7 years, well, multiply 7 times 15, that's how much rollback tax you're going to suffer should you end up having to or should you end up having, changed the use or violated the terms of the program in some way. So it can be very, very significant, the rollback tax assessment, 7 years worth of your tax savings. Now that does go, by the way, it has 6% interest, and that money actually goes into the purchase fund for ag conservation easements. That's also under the jurisdiction of the Bureau of Farmland Preservation at PDA. And the land is booted out of the program. It's removed from the program. Now, what portion of it might have caused it to be removed from the program is out, but you can re-enroll and start over again with those portions of the land that may not have been subject of the changed use. And we'll get to that, and hopefully that'll become more obvious if you're not following me. Now, there are exceptions and quirks to this, and that's what it's all about, really. Certain subdivisions, conveyances are exempt from rollback penalties if the qualifying use of land doesn't change. There's these things called split-offs and separations, which we'll get to. And then there's such a thing as rural enterprises, which is some type of ag-related, or doesn't necessarily, but it's ag-related business that's going on. And some of those within limits are permitted. And there's a lot more exceptions. We'll talk about those in a minute. But set those aside for a minute and just get the basic concept in your head. We'll have lots of time to talk about those. Now, again, the county tax office, tax assessor's office administers the program. PDA provides uniform interpretation, and that's an interesting phrase, and it takes various forms, but there isn't a whole lot of ability from PDA's standpoint other than to write the regs, which they do. But other than that, there's an interpretation question from an individual tax assessor's office in an individual county. PDA can say what they would like that county to do and how they would like that county to treat a certain complicated fact pattern. The county doesn't have to listen to that unless it's spelled out clearly in the regs. But there are so many things that come up that is not the case. Now, the other big thing that the PDA does is they distribute the annual use values upon which these reduced assessments are based, and they do that every year by May 1st of that year. Now, big qualification that you need to understand. Counties may establish use values that are lower than what the PDA publishes, but they cannot go higher than what PDA publishes. So that's sort of setting the the ceiling. The floor can go lower if an individual county wants to adjust its taxing between enrolled and non-enrolled properties, or the tax burden between those two types of properties. They can do that on their own, but they just can't go higher than those use values that are established statewide. Now, this is an example of how the use values look. And don't want to get too far into this, but this is like the beginnings of page 1 of the 2022 ag use values. And this is Adams County. And there's a map unit symbol, which is there's a map that goes along with this. And it's all based on the soil surveys. And so here's some of the descriptive language that is used to denote different types of soil classifications. And then so Adams County is essentially identified on a map as cut up into this and many more. This is just a very small part of Adams County's pages. But in any event, soil capacity class, you see that, or capability class, you see that. Class 1, class 2, etc. Acres in the area of interest is what AOI means. So that tells you that in Adams County, there's, let's say of the Arentsville gravelly loam, 3 to 8% slopes, there's 3,503.2 acres of that in Adams County. And it tells you what the percentage of that type of soil is in terms of Adams County's total size. And then it gives you what the per acre use value would be. Whoops, excuse me. What the per acre use value would be. These are pretty healthy numbers. Obviously, there are many counties where they're much, much lower. This is one of our higher use value counties in the state. This is a link over here to these. You can look at it, pages and pages of this every year published by PDA. Here is now the forest values, and they're slightly different. This is it's an average of these of the value of these various wood products, and this is the counties over on the left. So again, for Adams, it shows you this is the formulation, is this averaging of all of these wood product income potentials, and then gives you this weighted average based upon how much of each exists in the county, and it tells you what the forest use assessed value will be per acre. So you see some higher ones in the forested counties, well, like Butler, for example, but I do believe that, here we go, Elk County, bit higher, as you see here, 197. Not too many things in Elk County can say they're topping a list, but here is one. So that gives you an idea. And again, there's not too many pages to this. I think there's only like 1.5 pages of all the counties, but that's how the forest reserve use values look when you look at them. Okay, so this program, the big concept is that enrollment restricts the land use, and it just restricts the alienability of the land. So this is, not to be taken lightly. If those of us who went to law school, you very familiar with, the concepts of alienability and what goes along, the bundle of sticks that goes along with owning, real property. And this is a program that takes away some of your bundle of sticks, so to speak. So the landowner's acceptance of the tax reduction carries the obligation to maintain the acres enrolled together in one application, conforming to the qualifying uses requirements perpetually is the theoretical concept here. This is an obligation that runs with the land. Subsequent owners buy it subject to its enrollment in Clean and Green and all of the attributes of the application that was made when it was enrolled and what was going on there. And so the pays to, if you're buying property that's in Clean and Green, pays to get a copy of the application and see what's going on, because you don't always know that whether the local county tax assessor's office knows exactly how the property looks now versus and what's happening on the property versus what it was like when it was enrolled. So you better find out what it was like when it was enrolled and exactly what the representations were that led to this property being enrolled. Because if the change was made by the prior owner that the assessor doesn't know about, there's some factual things that you're going to have to address. To say that you may not be the one who changed the use may not get you very far, but you will be the one as the current owner who will suffer the rollback taxes. And if you haven't owned it for 7 years, you're going to be paying for something somebody else did, potentially. That maybe that's not quite an accurate statement under some circumstances. I got to think that one through. Now, the cost of the rollback tax and removal can be considered by this or a subsequent owner to be essentially the cost of doing business to develop land. Sometimes it's treated that way, and therefore use changes, which include dimensional use changes. In other words, if you're subdividing off a part or something, that's a use change. They can be done intentionally. But keep in mind, this is the big thing to be aware of. Let's say a rolled land was 100 acres. A change to an ineligible use in some way of even 1 acre of that enrolled 100 acres that was all in one application, that's going to cause a rollback tax on all 100 acres, not just on the acreage where the use was changed. Now, there are exceptions to that, but there are exceptions to everything. But this is the basic concept, and it can be very dangerous. This is really something to understand. The trick is not how to get in the program, it's how to stay in the program while still exercising the rights that you have in your bundle of sticks that accompany the land ownership. And that can be a minefield. Now, voluntary removal from Clean and Green is now allowed. And that was only as of 2010. There was a time when you couldn't even go and say, hey, county, I'll pay the 7 years. Here's my checkbook. I want to get out, and I'll pay the rollback. What is it? Give me the total. And you couldn't voluntarily remove in those days. Now you can, and what that would mean essentially is that you would intentionally violate the terms and then you'd be assessed the rollback and get kicked out. Now you can come forward and say, I want to be removed now. And then you have to pay the rollback tax upon the submission of the request to be removed. So it's an upfront, obligation. You got to be ready to pay. And then the enrolled acreage cannot be re-enrolled ever. So, that's the penalty for essentially saying I want out. You got to pay about the 7 years worth of tax and net savings that you realized all got to be, regurgitated back to the government. I'm still struggling with the right word for that. It's not, but in any event, it's clawed back, I guess. Some people would use clawbacks, but you can't re-enroll it. Now, this little box I have on this slide is very important because this is a realization where the light bulb went over my head at some point in time. I used to think, oh, clean and green is such a crazy statute. It's like Swiss cheese. It's riddled with all these exceptions to the rules that we just talked about. But now I sort of look at it differently. I sort of say, you know what? That's why it works, is because it has all these exceptions. Because, and this is my little thinking with these bullet points, if everything that I've said to this point in this presentation were sort of ironclad rules with no exceptions, the law would be very simple, but it would be very burdensome. And people would be very concerned about how can I subject my land to this, and give away this many, sticks in my bundle, so to speak. Or, how can I, impact its alienability this drastically and my ability to just do basic things on the property. It wouldn't, this program wouldn't have flown the way it has. As a result, however, of all of these exceptions, that's why it's working. And that's why the law, has essentially become not only, a great preservation of open space and undeveloped land, but it's also become the fundamental tool in Pennsylvania's efforts to prioritize farmland preservation. It is the first and the basic fundamental rule that encourages farmland and it facilitates farmland preservation, shall we say, even much simpler than an ag conservation easement. So farms need reduced property tax to be viable, and this program would not be providing that in the robust way that it is if in fact it didn't have all these nooks and crannies and all these exceptions that you got to steer through. So I kind of embrace the exceptions now. Now, this is something that very quickly, this just shows you on the left a table that tells you of each county how much is enrolled in each category of land use. Okay, and then it shows you how many acres have been terminated and I think these are 1 year figures. I'm sorry, I've totally botched that. It is telling you how many acres of each category have been terminated in these various counties in the year 2020, I think it is, because these were published in 2021, I believe. So it just gives you an idea of what happens in a year in terms of land being removed from the program, either by the voluntary means or by being kicked out because of a rollback and a violation of the terms of the program. On the right, you have the total amount of money that's been realized by rollback taxes in that same year. And again, I think this is 2021. So the first column is the money received as rollback taxes. And then the second column shows you how much money went into the Ag Conservation Easement Purchase Fund as essentially interest on that. In other words, you haven't paid for 7 years. Now you're giving us a check for 7 years worth of tax. Well, there's interest on that because we would have had this money a long time ago and we'd have been investing it on behalf of the county, if not for the fact that we're in this program. So that's why there's interest. So that shows you the number. Now, $11 million in a year, that's not necessarily that significant in terms of how much rollback is going on in a given year. Okay, now, big exception, something that you got to be aware of right now. The use value exception came into being as of 2016. That's what I'm calling it anyway. Effective in 2016, remember all that stuff I told you about the annual use values, and then the county must use that as essentially a ceiling over which they can't go in their assessment, but they can go lower. Okay, now that, just like everything in Clean and Green, not quite. What happened is in 2016, the law was amended so that the annual updated use values may not be employed by a county until the county performs a countywide assessment post 2016. So the use value for counties that haven't done a countywide tax assessment since 2016 are frozen at the 2016 numbers. Why? Because in counties without a reasonably recent reassessment, the use values were routinely getting increased because they were getting looked at every year and they were accurately reflecting the world and the conditions outside of the tax assessor's office, so to speak. While if they didn't have a recent reassessment, the actual assessed values of non-enrolled properties were not getting any type of freshening up or reflection of what's going on in the real world in the outside of the tax assessor's office. So if counties were not doing reassessments to keep up with the values, then essentially it stops. And so that is cutting their pocketbook, and it's incentivizing them to do a countywide reassessment. So it's a little bit of motivation by another tool to get countywide reassessments done. And of course, this was viewed as inequitable, that those who were enrolled were getting increases, while those who where there hadn't been a reassessment, they were still at drastically outdated numbers. And sometimes the use value that was going on, that was being published for use, for ag use, for example, was approaching or even exceeding the assessed fair market values. So it was like, why am I in this program? I'd be paying less if I was out of it. So that was, sort of the theory behind this. I love this. I love this statute because it has so many dominoes that fall, and they don't fall in the directions that you're thinking of. Now, this tells you what's happened since then. This is the ag use values by county. There's only a handful of counties that are actually using the updated 2021 values right now. The middle two columns show you who's been locked in at 2026 and still is locked in. And this is a very current, I think this is at least a 2021. Yeah, this is a 2021 because it says right there. And then other means they have done some kind of reassessment since 2016. So that tells you or some version of a reassessment, I guess is probably the right way to say it. It might not be a countywide yet. So anyway, that tells you a little bit about the current landscape in regard to using those yearly use values. And then this is the same breakdown for the forest use value, or forest reserve use value. Same situation, the columns mean the same thing. Okay, now let's take our deeper dive and start talking about all these exceptions, because then they complete the picture. Now you heard the basics. Now we're going to complete the picture a little bit. Here's the ag use definition. I know I only got 15 minutes technically. Okay, this is the definition of ag use. I'll tell you what, in the interest of moving forward and getting to our questions, maybe we'll come back. We'll just go through this and basically say that, it's for land use for the purpose of producing an ag commodity, or is devoted to essentially meeting the requirements of some type of soil conservation program agreement to leave it, fallow, so to speak. Some of the NRCS, conservation programs where land is, where it is not being used for producing an agricultural commodity, it's being essentially left untilled or unfarmed pursuant to an agreement with the federal government. It still qualifies for ag use in that circumstance. Okay, one thing to understand about ag use is that the farmstead where the farmer lives, if that is on the same, on the enrolled tract of land, that gets the same ag use value. And it's included in the farmstead and any of the buildings that are related to the house and the residential function, not the farming function. Those are treated essentially the same. as the portions that are devoted to ag. That's mandatory from the statute essentially. And then it can include other things, like if you're just a landlord leasing your land. And then, since the last less than 20 years, but in that ballpark, 15ish, it also is defined under the statute. Ag use is defined to include any land devoted to the development and operation of alternative energy system, if a majority of the energy annually generated is utilized on the tract. Well, that, under where the circumstances we live in today, encompasses solar development. So we all have probably heard some form or other of what's going on in the world with solar developments, and what happens with your clean and green enrollment if you put in one of these solar arrays on 30 acres of a 100-acre farm or something. It's dealt with in this exact language right here. If a majority of the energy is utilized on the tract, then it doesn't violate the terms of the ag use enrollment. Well, as you know, a big solar array, that's for commercial sale to the grid, so that would not qualify. So the solar rule is, if you're selling the electricity to the grid, or more than 50% of the electricity generated is being sold to the grid, it's a violation of clean and green. You have rollback and you're out. And the solar developers know that, and they have to deal with that. They have to pay that in order to go forward with their project. If you have your own panels that you're using for your own purposes, and you're using at least 50% of the power, and maybe you have a net metering for the rest goes back to the utility, you may very well be perfectly fine and in the ag use category of clean and green. You will be perfectly fine as long as you're using 50% or more. Okay, ag use. I'm just having this up here to show you that the standard. The standard ag commodities, being produced, or what it's all about. Except compost was added in 2012. So you see how this statute does respond to the times. Okay, the last note's all about the farmstead. Okay, ag reserve. This is sort of the category nobody wants to talk about. Non-commercial open space lands used for outdoor recreation or the enjoyment of scenic or natural beauty, and open to the public for such use without charge or fee on a non-discriminatory basis. The term includes any land devoted to, once again, our alternative energy language, if you're using it on the tract, if you're using the majority on the tract. Okay, so this is not being used to produce an ag commodity. It is essentially open space. Doesn't mean that you can't live on it, and that's become a point of contention here, because you notice how it says open to the public for enjoyment of scenic and natural beauty. Well, some people got property that they live on, and they consider it to be their property, and it's their homestead. And what, they're opening it to the public for use too? Well, then there were some people who come around the state doing things like finding properties in the ag reserve and then going there and spreading a picnic, a blanket out on the ground in somebody's front yard in their 15-acre McMansion, in some development of giant stately homes, and saying, "Hey, you're in the ag reserve. I can come here and enjoy the scenic beauty. I'm having a picnic on your front lawn." So there's been a lot of controversy over the legitimacy and integrity of this category. I'm not here to talk about that today, because we'd be here all day. All right. I'm just going to carry on, because again, that's a sort of a side issue. And then there's the forest reserve, which is essentially, capable of producing timber or other wood products. And of course, has to be more than 10 acres, the usual criteria. And it has the usual criteria for alternative energy. Okay. There's issues about the farmstead, but again, I got to keep going. So notes on enrollment issues. This is one interesting one, which is the first bullet point. A landowner may not enroll less than the entire contiguous portion of land described in a deed. So you have to enroll your entire property that's described on the deed. Now, ineligible acreage within that description won't get the tax break, but you need to enroll essentially in accordance with deed descriptions. Now, you can actually combine deeds and have an enrollment of more than of the complete description from 2 deeds. Now, whether you want to do that might be an issue because you don't want to, you kind of want to keep your application as small as you can, or single use too, because you can combine use. Because if there's a change in one, you don't want to have the ramifications. Remember that thing about the 100 acres, you change 1 acre and all of a sudden you get a rollback on all 100. Well, if I have several deeds and it totals up to 300 acres, you'd be better off, sticking to the deeds, and then the consequences for some type of a rollback would only apply to that enrolled parcel, that we're on that one application. So this is sort of an issue, and certain counties have some issues with regard to how they do that, but just be aware that goes on. Okay, I'm going to keep going so that we can talk about a couple more really important things. There's 2 concepts in clean and green: a separation and a split off. A separation is essentially you're safe. You're not booted out of the program. You don't have a rollback. What's a separation? A separation is when you have an enrolled parcel, and then by a division, could be a subdivision, or conveyance or other action of the owner, it's now been broken up into 2 or more tracts of land with separate deeds generally, and that's okay as long as the property remains qualifying both parcels. So if you have 100 deeds and there's 2 brothers and they decide, we're going to subdivide, each one of us is going to take 50. As long as they keep doing what they were doing when they enrolled it, doing that is fine. And nobody gets booted out of the program, nobody suffers a rollback. Split off, however, is a different story. In that situation, you get a rollback and you're out. And what that is if you see the definition, almost the same thing, except by the process of this conveyance or other action, one of the parcels that was created is no longer eligible because something is happening on that property that it violates the conditions of its enrollment. It's too small now. It's less than the 10 acres to, it's less than the minimum size to qualify anymore, or something else about what's going on the land has changed. It's no longer in technically ag use. So that's the 2 concepts to be aware of. Now, this is an important one, and I might try to really wrap it so we can get to these questions. How many do we have, Audrey? Are you answering some of them by offline? I see here.
I have not answered any questions.
All right, maybe somebody else did because they've gone down.
Well,
okay.
No. I'm responding, so I'm collecting.
Right. Yeah. Okay. So a split off that is less than 2 acres is permissible. And it can be over 2 acres, up to 3 if you have a minimum lot size requirement in your township, for example. Split off of 2 acres, less than 2 acres, which remains in an eligible use or is used as the owner's residence, is permitted annually without impacting all of the other land, provided that there hasn't been 10 total acres split off in this way since enrolled, or 10% or less has been split off in this way. So what I always like to say is, when you drive around and you see, rural roads, and then you see all of these homes that are stuck along the road frontage, and then the farms in the back, and it's going up over the hills and into the woods and everything else. But the road frontage gets all the subdivided little houses so that the farmer can make income. Well, that's how they're doing this. Every enrolled property can have 2 acres done every year in this way to generate money for the landowner, and up to 5 years worth of doing 2 acres a year. In other words, a total of 10 acres can be done in this way. You could have 10 1-acre lots split off, but that's why all the road frontage gets sold off and the farm continues in the background. It's because that's allowable with clean and green land if you do it right. And then that only rollback is on that little tiny piece of property that you've split off. So that's one of the huge exceptions that allows a farmer to still exercise those things that are in the bundle of sticks, because they can sell off essentially building lots. and not suffer consequences. Let me go back for 1 second. Oh, wait a minute. I'm going the wrong way. There we go. Okay. Now, I'll leave it for that at that so we can get to questions. So I do have a bunch more slides, but I'm going to try to get through. I've actually only got 4 more. Okay, now this goes to the long laundry list of exceptions that exist. And what did I do? I do that constantly. Okay, so there's a whole bunch of exceptions that have essentially become this, what I was calling the Swiss cheese. They're, less than a half-acre cell tower leases are okay. There's no rollback. Now, that's the simplification, but that's the gist. Gas, oil, coal bed methane exploration and extraction leases are okay without rollback on everything, but the entire enrolled parcel, just on the area that's utilized for this type of energy exploration and extraction, so to speak. This is an extremely complex issue. I dealt with this as chief counsel intimately in terms of the language that exists in the law now. We won't talk about that. It's Ross Pfeiffer, our director at the center, has given multiple presentations on this issue. It was a very hot issue 10 years ago, let's just say. Now, some exceptions carry a duty to report to the county assessor, by the way, what you're doing on the property, because they don't have people out there patrolling to see what's been happening with all this clean and green property. There's not a lot of enforcement troops on the ground out there. Wind power generation has its own specific exception and the rollbacks only on the little part that the wind, that the windmill would be mounted on. So not a big rollback. There's no specific solar exception. I told you how solar works before. It's all in the definition of the different uses. Pipe storage yards for pipelines, they have their own little exception. Everybody came and got an amendment to the statute for their little tiny thing that they need to do in rural areas on land that is very highly likely, let's say, to be enrolled in clean and green. Small non-coal surface mining. Again, only the acres that are utilized, there's a rollback. So there's a preservation of the enrollment and a very small rollback in comparative terms. Recreational activity with or without a fee on ag or forest reserve doesn't disqualify the land as long as it's not rendered incapable of being converted back to ag or producing timber and wood products. So this is like the ATV trails and things of that nature where you're not really doing a whole lot of permanent changes to the surface, but you're letting recreational use of land that's in ag or forest reserve, even with a fee. And state administration transfers. This can be complicated. But the basic gist is, well, if somebody dies and then the property has to be split up, as part of the state administration, then, there's not a rollback. But then if one or more of the estate beneficiaries changes use, well, then they pay a rollback on their portion, not the whole global rollback the way it normally works. There's other, like all sorts of donations to school districts and churches and cemeteries. So you can see the kind of things that get their little carve out. Okay, last one. Sorry, Audrey, but I got to do this.
That's okay. We're going to extend.
Okay, we're at 1, and this is my last slide of substance. Okay, rural enterprise exception. This is a biggie, and so I want to take a sec and say, okay, a landowner may apply a maximum of 2 acres of an enrolled tract for direct commercial sales of agriculturally related products and activities, or a rural enterprise incidental to the operational unit. And being from Lancaster County, I always say like, oh, well, the Amishmen that have the harness shop where they do all of the leather and the bridles and all of the work for, horse and buggy transportation. That is a rural enterprise incident to the operational unit. It's not agriculture related products and activities per se, but it is, fits within the definition of rural enterprise, let's just say. And then there are some qualifications within the definitions of what qualifies as a rural enterprise. And so that's listed here, so that just be aware. Now, there's also the a sort of a separate exception that gets buried under this rural enterprise, which is there's no rollback tax and no breach of the preferential assessment, no rollback and no booting out of the program if in the sale of direct commercial, or excuse me, in the direct commercial sales of agricultural related products that, and there's 3 criteria, take no more than half an acre for the actual sales location, or what you're selling is at least 50% products that were produced on the site, and that there's no requirement for a new building or buildings. And I just had somebody call me the other day who got a rollback because a little tiny shed that they put in for, and I forget exactly what they were doing, but it was the most minimal, but they got a rollback because you had to have a new building for that. And it was a temporary building that didn't even have a foundation, but in any event. All right, so that's the basic gist. Let's go to these questions, all right?
All right. Okay. We have got so many. And so we're going to extend this program, I guess, until about 1:15 or whatever. If you have to log off, that's totally fine. We understand. Those of you, who are watching for CLE credits.
So are these in the Q&A or the chat? Sorry.
I'm gonna ask them to you.
Yeah, go ahead.
Otherwise, right.
All right.
Okay. So we're kind of, I'm going simplest, I think, to most complex. So the first one is, does the prohibition on re-enrollment of land in clean and green, the prohibition that arises once the use restrictions have been violated, apply to a subsequent purchaser or other subsequent transferee? In other words, does the prohibition on clean and green re-enrollment, quote, run with the land?
Okay. Now, keep in mind, the prohibition on re-enrollment only applies if you have done the voluntary request angle. In other words, it's not that you suffered a rollback because of something you did. It's that you asked to be unenrolled voluntarily before you went ahead and did those things. And so that is, the answer to that is yes, as to if it was done by virtue of a voluntary request to be unenrolled. But it doesn't apply for any of the other sorts of rollbacks. It's very common that when there's a rollback of like 100 acres, because you did something, on 15 of those acres or whatever, the 15 go, everything's booted out. The 15 is never going to come back, but the other 85 acres can be re-enrolled, and that would be allowed for the subsequent owner too. Okay, go ahead.
Okay, good. We also have, can a county exit the clean and green program once it's set up? Would that be practical for the county? I'm thinking probably no, but can a county exit?
Well, that's a tough one. I've never heard it happen, and I don't know the administrative nightmare that would all involve. There is, to some degree, I think there'd be some very significant litigation because these people have enrolled in what is a perpetual, benefit program. And to take that away in, the way that this is suggesting is probably going to be subject to some serious litigation, probably constitutional takings litigation. So that's my best answer.
Yeah, that sounds good. Okay, and then we've got, can a county assessment office levy a penalty if a property owner does not give the required 30 days advance notice prior to a change in ownership of a clean and green enrolled parcel? So can penalties be levied at the county level?
I don't think that's a good question. I don't think they can do that because it's not authorized in the statute. They can have their own county terms for administration of their program, as long as they're not doing something that is not authorized by the statute or is somehow contrary to the statute and, I should say, state regs. So I got a feeling, I don't know totally, but I think that would be a no-no. I know that Stephanie would know and Doug Wolfgang would know. Stephanie's
right.
In the meeting. Okay.
I'm gathering from these questions that there's quite a disparity in the administration of this program.
That's right.
Maybe that's an understatement.
That's right.
Here.
From county to county, there is a lot. And,
right.
And it's not without a lot of controversy.
Which kind of leads us into this next question. It says, section 5490.4b, requires assessors to use the contributory value of farm buildings. Can you discuss how that's practically applied? And that was from Joe Montenegro, and then
Yeah.
James Kilgore follows up. Yes, on contributory value. I know 2 county assessors who do not take this into consideration. And he says assessors in different counties interpret clean and green regulations differently. Are they allowed to? So it sounds like, so how is this practically applied, this contributory value? And are they even supposed to be doing this differently, I guess would be.
I do believe that. I think the answer is, I mean, yes. And I know, okay, so the question is, can you, yes, obviously it should be done. Can you discuss how that's practically applied? That's a good question. I'm sorry, Joe. I have to think that one through a little bit, and maybe let's talk about it offline here.
I think it bleeds into
Right.
Mr. Kilgore's question about that assessors in different counties interpret clean and green regulations differently.
Right.
And so
Yes.
they're allowed to do that.
Yes, within reason. And this is probably something that you need to take up with Stephanie Zimmerman at the, Bureau of Farmland Preservation. That's because in the end, if there's a mouthpiece for the state government, I don't mean that in a bad way, if there's a mouthpiece for the state government in its role to interpret and uniformly across counties, it's Stephanie Zimmerman.
Okay. Okay. All right. So we'll just kind of keep going here. This is James Correll. He says, do subsurface only gas and oil leases violate clean and green and cause rollback?
Well, that's in other words, nothing's been done on the surface yet.
Correct.
And that can be, that can also be a unevenly interpreted idea, but that's a common theme, which is, okay, I did something on paper, but it hasn't had any impact on the surface yet. So, and generally, most of those issues get resolved in ways, at least when they're addressed in the statutes or the regs, they get resolved to say, only when the surface becomes impacted does that thing that you did on paper have an actual impact on whether there's going to be a rollback, et cetera. So, like for example, in the oil and gas leasing area, it's very specifically spelled out when does the actual rollback become effective. And actually, the way it's set up is, you don't have a rollback until there's drilling, but then once there is drilling, the rollback, I believe the way it's worded, look at me, I can't even remember exactly. I believe it's the way it's worded is that it's retroactive then back to when the lease was executed. Could have that wrong, and Ross might be able to jump in there. But the bottom line is that's a recurrent problem, and it's not uniform. Again.
Okay, and then I will also just add to that, like on Pennsylvania Department of Ag's website, their clean and green, one of their little questions here, it says, may I engage in mining on my clean and green property? And this says the program was recently amended to allow for one small non-coal service mining permit on enrolled land. Rollback taxes are due on the affected areas. I don't know if that's helpful or not.
And I would say, yeah, if you want to know, right, like in that instance, it would be, well, you cut the lease with somebody, but they didn't start mining for 10 years later. And I believe I think that one came along after the gas drilling exception, and I think they just used the same language but you'd have to check the statute. It's easy to do though.
Right. So I guess the overall answer on that is like maybe, and it kind of depends on the specific facts of the person.
And read the statute.
This, right.
Because each exception has, lots of fine print.
Okay. And then we've got a question from Chris Vanderman, who I think jumped off, but we'll email this person. They asked, how does clean and green assessment tie into the agricultural use schedule in the Pennsylvania inheritance tax? Is proof of the clean and green assessment mandatory to secure farm, forest, open land exemption from inheritance tax? So do you have to be enrolled in clean and green?
I don't think so.
Tax?
I do not think that's tied together in any way.
Okay.
That would be a state and probate code question, but I do not believe that is tied together.
Correct. That seems logical to me.
Yeah.
And then, okay, this is a fact pattern. We'll just keep going. We've got people on.
Okay.
If you've got to log off, you got to log off. That's fine. I'll try to do my best here. Okay, so There's a situation, we have separation of tracts that retain clean and green and then deeded to a third party. The new owners apply and are approved for clean and green. A year following that, the new owner voluntarily withdraws their acres from clean and green. Does that affect the original separation? Whoa, okay.
All right. Well, I'm confused because they talked about a separation and then an enrollment. Well, they already were enrolled when they
Right.
separated. So I'm confused. Yeah. Right. And that
Separation. Okay. Yeah. So we had tracks, we separated them. The tracks retained the clean and green. Then we
Okay.
deeded. I'm not sure if this is both tracks or just one to a third party. The new owners apply. Okay. So you have like transfer of land that's
Yes.
already enrolled and that's going to a new owner.
Yes.
Then the new owner voluntarily withdraws. Does that affect the original separation?
Oh yeah. Okay. That's not actually a very, very unusual question. Okay.
Yeah. Okay.
The basic rule, and again, it's not hard to read the statute, and I don't always have it completely memorized. The basic rule is that the statute generally puts the burden of rollback for a changed use upon the party who changed the use. And if there has been a separation, then the party who does not, whose land remains, is not going to be responsible for the rollback, or remains eligible, I should say, is not going to be responsible for the rollback. So then you have to take that basic rule and go in and look at the statute and sort it out to figure out whether is the new party that changed the use, so is he going to have to pay the rollback on everything, even the stuff that he doesn't own anymore, or does he only pay on the stuff that he owns, the acreage that he owns? And I got it on the spot here. I just have to sit down and read it again to sort that out. But it's hard to. I haven't memorized that enough to, or it's my muscles that used to know this better are not as exercised as they should be, but that's not a hard question to answer by reading the statute.
Okay. So, but it sounds like the new owner is on the hook for the rollback tax.
Change. That's right.
Change
generally, the rule under the law is that thou who changed the use shall pay the rollback tax.
And then the ultimate question here is, does that affect the original separation? I guess like you wouldn't have to put the tracks back together.
No, I think what he means is, does the person who didn't do anything, and has one of the separated tracks, do they have to pay something? That's what he's asking.
Right, think, right. And so we think.
Right. And I do believe that the answer is no, but you have to double check and look at the way the statute's written on this particular point.
Oh my gosh, we got so many. Okay. James Kilgore has asked us so many questions, so we're going to get to these here.
Why don't we do this? Mr. Kilgore, if you're still with us, why don't we go offline here? Sounds like you got lots of questions. Sounds like you should probably go to Stephanie Zimmerman for a bunch of them, but we'll help you at the Ag Law Center. If you want to get in touch with me, Mr. Kilgore, just send me an email, dhd5103@psu.edu, and we'll try to sort through them.
I've already sent you an email with his info, so I'm gonna just like copy all of his questions into an email and send them to you, because he's getting really kind of in the weeds with some.
Yeah, probably not the place for this. Okay.
Yeah.
Got it.
Fact patterns.
All right.
But I hope we got through everyone's questions. If you have more, please email us and we'll get them to you. And we may put something together and just publish this on our website with our answers here.
Yeah, it's a good set of questions. I'm really happy with everybody who attended and everybody who asked questions. I knew this would be a hot topic. I didn't know we'd have 17, but that's great that we do. Yeah. So really appreciate the questions.
Cool. All right. Well, thank you all so much for attending, understanding the basics of Pennsylvania's Clean and Green Preferential Tax Assessment Program. Please join us again in March for animal confinement laws. So thanks all so much. We'll see you in March.